Okay, folks, we're live. Shannon, put us back on, please.
Go ahead.
Woodard versus Woodard. And we need to put some proofs on the record, Mr. Trushin.
Thank you, Your Honor. We would ask that you allow us to do that. Yes, sir.
Okay, Mr. Woodard. You can hear me okay?
Yep. Yes, sir.
Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down now. Just state your full name, please.
George David Woodard.
Mr. Trushin, go ahead.
Thank you, Your Honor. Mr. Woodard, there came an occasion where you came to my office indicating that you wanted to file for divorce. Is that correct?
Yes, sir.
And your wife's name is Kimberly Lynn Woodard.
Yes.
And at the time you filed and signed the complaint for divorce, sir, were the allegations contained therein true and accurate?
Say that again.
Were the allegations that you signed on the paperwork for the complaint for divorce, were they true and accurate when you signed them?
Yes.
Are they true and accurate today?
Yes.
And it's your request that this judge grants you a judgment of divorce. Is that correct?
Yes.
At the date and time that you in fact signed the complaint for divorce, had you lived in the state of Michigan for at least 180 days and 10 days in Jackson County prior to filing?
Yes.
And you're still a resident of Jackson County, is that correct?
Yes.
Along with your wife?
Yes.
Right. Is the best of your knowledge, your wife pregnant at this time?
No.
To the best of your knowledge, are there any minor children currently in your home at this time? Your children are all grown. Is that correct, sir?
Yes.
All right. And would it be a correct statement that there has been a breakdown in the marital relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood of reconciliation between you and Mrs. Woodard?
Yes.
Now, I'm going to go through the provisions as I understand them, and they've been presented to me. Neither one of you are in the military service also. Is that correct, Mr. Woodard?
That is correct.
Please tell me and correct me if I'm wrong, so the judge has the complete facts in regard to what your settlement should be. Okay?
Okay.
Number one, there is a marital home located at 616 Lake Street, Jackson, Michigan, 49203. That home will be kept by you as your sole and separate property. And Kimberly would sign off on a quitclaim deed, relinquishing any and all interest she may have at that home. Is that correct?
Yes.
You will assume any and all indebtedness on that home. The only thing that Kimberly would be responsible for is the day-to-day electricity, utilities of any nature on the home while she lives there.
Yes.
It is my understanding also that in fact, she is going to be allowed to live there with just paying the utilities for 90 days from the date of judgment. Is that your understanding?
That's Gracie.
Okay. Is that your understanding, Mr. Woodard?
Yes, it is.
All right. So at the expiration of 90 days from the judgment of divorce being signed by the judge, Mrs. Woodard would then vacate the home. Is that correct?
Yes.
Okay. And again, during that 90 days, she is going to pay all the utilities. You are going to pay the mortgage because you are going to receive the home pursuant to this judgment of divorce.
Yes.
Okay. Now, is it also your understanding that you will retain complete ownership and sole ownership of your business to include any and all tools of any nature, any and all equipment and vehicles related to that business, and retain any and all accounts as they relate to the business, known as George Woodard doing business as GW Construction?
Yes.
Right. Also, you have 3 vehicles listed. That the 2000 Tahoe is to be your wife's sole and separate property, her vehicle that she was keeping out of the divorce action. Is that correct?
Yes.
And she will assume any and all indebtedness in regard to it.
Yes.
Of any nature. Also, you are to receive your 1989 Corvette and the 2003 GMC. Those would be your vehicles. Is that correct?
Yes. Yes.
You would assume any and all indebtedness on those vehicles and hold her harmless like she would on the vehicle she's receiving.
Yes.
Right? Now, you're each to pay your own personal debts of any nature. You don't have any joint credit cards or joint accounts, things like that. Is that correct?
We have one joint, I do believe we have a checking, but other than that, credit cards, no joint credit cards, nothing like that.
Joint other debts, nothing
No.
like that, no joint,
Nope.
okay. And then what is the pleasure between you and your wife in regard to that one account?
She can have it.
Okay, so the personal account checking would go to Kimberly, is that correct?
Yes. That's where her social security check gets deposited. So yeah.
Okay, all right, so she could keep that and you would sign off on that, so it'd be just her sole and separate property.
Yes.
All right. Any other debts whatsoever between the two of you?
No.
Any debts you can think of whatsoever? No other credit cards, no further debts of any nature, all right?
Nope.
All right, it's my understanding that all the guns, you had an extensive collection of weapons between you and your wife, that all those have been divided, including the safes, and that what you have in your possession now as far as guns and safes is yours, and what she has in her possession as far as guns and safes are hers. Is that correct?
No, Gracie. No,
Yes.
Okay.
no.
It's my understanding that any and all personal property, to include any and all tools of any nature, both personal and through your business, would be your sole and separate property.
Yes.
It's my understanding that the riding lawnmower would be Kim's sole and separate property.
Yes.
It is my understanding that the sports memorabilia will be divided on a 50-50 basis. First of all, the two of you will attempt to sell the sports memorabilia within the next 6 months. If that cannot happen or does not happen, that in fact you will, with Kim, divide that memorabilia on a 50-50 basis between the two of you.
Yes.
You understand if that can't be done between the two of you, somehow there becomes an issue, that this judge will retain jurisdiction to make that determination who gets what of that sports memorabilia.
That is fine. Yes.
It's my understanding that Kim is to get the 55-inch TV,
Yes.
and that you are to get the 50-inch TV.
Yes.
The baseball cards, it's my understanding that collection is to be your sole and separate property.
Yes. She didn't want nothing to do with the cards.
Okay. It is my understanding that the Edward Jones investment account is to be your sole and separate property,
Yes.
and she will sign any and all documents to effectuate that.
Yes.
It is my understanding the Franklin Templeton investment account is to be Mrs. Woodard's sole and separate property, and you will sign any paperwork to accommodate that transfer solely to her.
Yes.
It is my understanding, sir, that in fact, if either one of these, we're hoping that they just require signatures from both of you to do that. But if in fact, either one of these accounts are in need of what's known as a quadro, qualified domestic relations order, that both of you will cooperate in regard to the preparation of that and divide any and all fees and costs on a 50-50 basis to accomplish the transfer of those two accounts. Is that your understanding?
Yes.
Okay. It is my understanding also that in fact, there is an alimony award that you will be the payer to Kimberly in the total amount of $7,200, a lump sum, $7,200 and nothing more. And that's payable at $200 per month.
Yes.
Is that your understanding?
Yes.
Also, my understanding that you want to have the option to pay that off or make lump sum payments directly to Kimberly of that $7,200, should you come into other cash or want to make a lump sum payment to her towards that balance.
Yes.
All right. Also, that in fact, you understand by law
You watching
that
the screen at all?
the $7,200 alimony award would cease
Just made its appearance.
if any time, number one, you had paid that in full, the $7,200, or she remarries, that your wife remarries, it would cease, or the death of yourself or the death of the payee, her. So again, I'll go through that. The only way that in fact the alimony award would not be paid in full would be number one, if she remarries, number two, if she passes away, number three, if you pass away, or number four, if you have paid the $7,200 to her.
Yes.
All right. Your Honor, if I could have 1 second.
Come here.
Time's up.
My understanding also, sir, that each of you will pay your own attorney fees.
Yes.
It's my understanding also there are 2 accounts, life insurance policies with Western and Southern Insurance Company. Now, I'm not familiar with them, but the judge may be. But my understanding is, Mr. Woodard, that in fact, you are to get as your sole and separate property, clear from any claim of your wife, the account number 463199193. Is that your
Yeah.
understanding?
Yes.
No,
And also that your wife is to get and retain as her sole and separate property, free of any claim from you,
no.
her
Receipt.
account with
Receipt.
Western and Southern
We're
Insurance,
almost done.
account number 7720986. Is that your understanding?
Yes.
I know, hang on. Hang on. We're almost done. Yeah,
Mr.
Go get your
Woodard,
baby.
while I'm confirming the rest of the property, do you have any questions so far in regard to what I've indicated that's going to happen to the property?
No.
Okay. Mr. Woodard, you understand, I will go through these other provisions
I
that
don't.
there'll be a provision placed in the judgment of divorce that would indicate if Mrs. Woodard desires her maiden name of Loring restored to her, that she would have a right to that.
Absolutely.
And also that there be a provision indicating that any and all property that you receive or any and all property she receives through this judgment of divorce, you would be responsible for your paying whatever that might be on that property, and she would be responsible paying for whatever she would receive on that property. You understand that?
Yes.
It is my understanding also that as far as health insurance, upon the signing of this judgment of divorce by Judge LaFlamme, that each party will be responsible for maintaining and obtaining their own health insurance. You understand that?
Yes.
So you'd have to get your own health insurance, Mr. Woodard, and Kimberly would have to get her own health insurance. Each one of you would pay for your own health insurance account. You would have no further responsibility paying for Kimberly, and she would have no responsibility for you for any health insurance issues.
Yeah.
You understand that? Okay.
Yes.
Any and all other bank investment accounts, sir, that you have that I missed?
No.
Okay. Stocks and bonds?
Nope.
Nothing? Your Honor, I would ask also that we place in there the anti-bankruptcy clause, as well as the statutory insurance provision, the execution of documents. The provision in lieu of dower is no longer necessary, it's my understanding. The bar of claims provision, non-disclosure of assets, should either one of these parties locate something that was not discussed on the record today, or it be different than what was discussed on the record today, as well as retention of jurisdiction by this court. Attorneys' fees each pay their own, and the provision in regard to once the judge has indicated and signed the judgment of divorce, that the attorneys are discharged from that current representation. I believe with that, Judge, that concludes our provision in regard to the property distribution.
Mr. Woodard,
Yes, sir.
what is your most prized baseball card?
The one that means the most to me.
Sure.
Okay. I got to tell you a story. My Uncle Butch is the one that got me collecting baseball cards. And he got this book of addresses of baseball players, football players, and stuff like that. And he gave me this Willie Mays card. And we both wrote letters to hopefully have him sign it. And about 6 months later, I got mine back autographed, but I think it was because I was 11 years old. He never got his back. I got mine back. He didn't get his back. So I would have to say that that one is probably the most prized. Or this might sound really weird. You remember the movie A League of Their Own?
Yes.
Okay. I can't remember where exactly this young lady was at, but there was a Vivian Kellogg that played in that league, and my sister was a Cena for her, and she autographed the card for me.
Oh,
She's from Brooklyn.
Yes, yes.
that's amazing.
So I have two autographs. One which was really nice, but the other one when she was getting kind of old, and it was really, really shaky. So
Wow.
I would have to say that those are probably the ones that mean the most to me.
Great prizes indeed.
Oh, that's cool.
Ms. Woodard,
Yeah.
I want to talk to Gracie.
That's easy.
Hi,
Great.
Gracie.
Hi, baby.
You can't touch.
Hi, Gracie.
Aw.
What a sweetheart.
This is how she
And,
does her Head Start classes.
Aw.
I saw a cat briefly make an appearance. Who was that? Looked like
Peaches.
one that looks like one
That's
that we
Peaches.
have. Ms. Woodard, can you confirm for me today that you are not pregnant?
I'm what?
That you are not pregnant?
Oh, no, I'm not pregnant.
Ms. Duncan, did you wish to excuse me, voir dire Ms. Woodard about the terms of the divorce judgment?
What? Well, give it
Uh-oh,
here.
Shelley's frozen. We lost her. Hold on.
Well, give it here. Let me see. Grandma will help you. Give it here.
My guess is she's trying to log back in. Or her internet went out completely.
Give it here.
Mr. Trushin, do you have her phone number handy? I could try getting her on the phone. She might have lost her internet.
I do, Judge. Are you ready?
Go ahead.
Is John 745-1569.
Actually, I got a phone number in here that looks like a cell number. Let me let that one in. That's probably her.
That's probably the one I gave you.
Is this Ms. Dungan? I just let somebody in with a telephone number ending in 6869. What's your name?
Jennifer Farrell.
Hold on a minute.
She's not sure what
Miss-
happened. She just texted me.
Okay, let me put, Ms. Carroll, I'm going to put you back in the waiting room now that I know who you are. We lost somebody else and I was trying to track her down. All right, I'm going to try that number now. She must have lost her internet connection.
She just texted me. She says she doesn't know what happened.
It didn't go through. Let me try again. It does this sometimes.
This is my first Zoom meeting. I have no idea.
Yeah, my guess is she just lost her internet connection.
Hello?
Ms. Duncan,
Yes, what is is it me?
did you forget to pay your Comcast bill?
I'm going to have to talk to Mike about that. He's in trouble.
So we are still on the record. Did you wish to voir dire Ms. Woodard about the terms of the divorce judgment?
I do. Thank you, Your Honor. Kim, you recall being in a settlement conference in my office. Is that correct?
Yeah.
And you remember all the terms, and we did reach an agreement that day. Is that correct?
Yes.
Okay. I'm Gracie, as lovely as she is, I don't know if she distracted you. Were you able to hear all the terms that Mr.
Yeah.
Tushin put on the record?
Yeah, I heard.
Okay. So do you agree to abide by that settlement? You heard all the terms, correct?
Yes.
And you
Yeah,
believe
I
it to be
agree to
fair
it.
and equitable? Go ahead.
Yes. Yeah, I
And
agree
you
to
agree
it.
to abide by it. Is that correct?
Yes.
And to the best of your knowledge, you're not pregnant today. Is that correct?
No.
Judge, I have nothing further.
Thank you. I'm satisfied based upon the testimony that there's been a breakdown in this marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood that the marriage can be preserved. I will sign that consent judgment of divorce upon presentment. I also find for the record that Gracie is an absolutely darling young lady.
She is a total blessing.
She's
All
something
right.
all right.
Judge, can I ask one thing while the parties are here? The one thing that I
Certainly.
neglected that counsel and I spoke about, and that was whether Mrs. Woodard would like the $7,200 in alimony paid to her directly by Mr. Woodard or through the friend of the court.
It can be paid directly.
Okay.
Perfect. That'll work out really good.
I will put in there also,
Yeah.
Judge, then a provision should Mr. Woodard default in regard to that, Mrs. Woodard would have the opportunity to petition the friend of the court to then have it made payable through them.
Fair enough.
All right, Judge,
Sounds
would you enlighten my client and Mrs. Woodard my nickname for the court?
Well, if you insist, we are live streaming this right now, George, but
I have no trouble with that, Judge, whatsoever.
Well, Captain Kangaroo.
Nice. That's awesome.
All right.
The worst part about this, Judge, is that at my age now, I just think that's all funny and enjoy it. That's Well, these people, Judge, for your edification, and Shelley have been a joy to deal with. They were nice people. They listened to our recommendations, and it was an absolute joy to work with the two folks, as well as Miss Duncan. So,
Great. Thank you, everyone. I need to move on to the next pretrial. So have a good day.
thank you, Judge.
Thank you, Judge.
You're
Thank
welcome.
you.
What, babe?
Okay, Mr. Ramey, can you hear me? Apparently not. And I'm having trouble connecting to Mrs. Ramey. Maybe I'll try calling them. I've got a phone number.
Hello?
Ah, yes, Ms. Ramey. I'm having trouble getting a audio connection with John. I'm going to try to call his phone number.
Okay, that's fine.
And it did it again. It's not ringing through. Let's try again. Mr.
Please
Ramey?
leave your message for 5-1.
Was he initially on the Zoom?
He
might be
is there, but I don't have an audio connection.
Oh, he might not.
So
I know
I'm
when it
gonna
just
hold-
alerted me, I had to push the, what was it, the Wi-Fi. It said something about dial in or whatever. And I pushed the Wi-Fi and the cellular, and it connected me to you. Maybe he didn't.
Hello?
Mr. Ramey,
Yes, sir. I'm trying. I'm on the Zoom call.
Oh,
I
yeah.
just, I can't hear anything.
I know it. I could see you and could tell that you were connected, so I just dialed your phone number. Were you able to see the note I held up to the screen?
No, sir. And I've never done this before in my life. So I'm like so computer not savvy.
No problem.
I'm trying so hard, Your Honor.
No problem, sir. We can do this by phone. So
Okay, awesome.
Ms. Ramey is present.
Okay.
Your case is scheduled today for a pretrial.
Yes, sir.
Because this is a short-term divorce without any children born during the marriage. What I decided at a pretrial is whether it's necessary to hold a trial.
Right.
The trial would involve division of property. Have the two of you already divided all of your personal property?
Right. Well, there's one issue, sir. That is a motorcycle that I have, and it's we've gotten $20,000 for an accident we got into, and I split it with her, and I offered her to buy my motorcycle for $1,500, and she only gave me $250, so I still have the bike. She never paid for it, and I signed the thing over to her a while back, like right away, because she said she'd give me the money, and she never did, so I held on to the bike.
So you've actually signed over the title to her, but you've retained possession of the motorcycle.
Yes, because she never paid for it. Yes.
I'm assuming the motorcycle is not drivable in its current condition?
Well, it has crash bars, so it doesn't have a scratch on it. The only problem was the fender that got broken on it. Other than that, it's in perfect condition.
Oh, okay. Ms. Ramey, do you acknowledge this?
No, that's not true, Your Honor. The situation with the motorcycle was that initially he said he would give it to me if I would sell someone else from the club my bike that I was on when we got in the wreck. But then I told him it wasn't his place to do it because it was my motorcycle. So with that being said, when I went to Virginia with my daughter, it was New Year's. I got back New Year's Eve, which would have been 2019 going into 2020. He had the part about the motorcycle money or the rack money is true. We did split that. And so when I was down there, he asked me several times if I would pay the rent because we made an agreement prior to the check even coming that I would pay X amount of dollars in bills. He would pay X amount of dollars in bills.
So Ms.
So
Ramey,
anyway,
let me,
he said
let me
750,
stop.
and then he said, how about I give you give me 350, and I said I'll give you 300. He brought me the motorcycle title. I said it's not signed. He signed it. I said you need to print your name. He said you can do that. I said no, you need to print your name. He gave me the title. I give him the 300, and he said you weren't kidding, were you? There was never a discussion about no $1,500.
All right,
and later
all
on,
right, let me
said,
stop, Ms. Ramey. Ms. Ramey, let me stop you.
Okay.
So today, your case is just scheduled for a pretrial. So save your words about what's in dispute because I'm not going to remember it. But if you can't work out the motorcycle, is there anything else other than the motorcycle and his claim that you still owe him some money for that? Is there any other property to be divided?
No, and that motorcycle I give to my mother because I had nowhere to stay. I stayed with her and I signed that motorcycle over to her for payment for taking care of me when I was thrown out. So it's not even his nor mine at this point. It hasn't been.
All right.
Yeah, she hurried up and put it in her mom's name.
No,
All right, but in any event, Mr. Ramey apparently still has the motorcycle.
Yes,
correct?
he does. He's only doing that because
And you hold on, ma'am.
Okay.
It's best if you just listen to me, okay?
Okay, that's fine.
And answer briefly because I'm not going to remember this. So what's going to happen is since you guys are still arguing over property and who owes who what, that's something that I decide at a trial, not at a pretrial. Your case is currently scheduled for a trial. Let me confirm the date. Looks like it's April 29th, so next week.
Well, Your Honor, I don't mean to interrupt, but it says that it had been changed because you weren't available, so it had been changed to May 20th, I believe.
Oh, okay, that hasn't made it to the file yet. I'm just looking at what's on top.
Okay.
So if you got a new notice, that's what it is, May 20th. So here's what's going to happen. I will see you back here on May 20th. And at that time, I will hear testimony from both of you. And I will decide what's to happen with the motorcycle, what's to happen with any remaining payments that either of you claim is you are owed. And I will take whatever proofs are necessary in order to finalize your judgment of divorce.
Okay, I have a question.
Thank you very much, sir.
I had initially wanted to go, my last name to be returned to Oberlin. My daughter just recently got married and I was going to go back to that due to her. But is there any way that I could change that to go back to my maiden name, which is Pruden, Pruden?
Absolutely. You can have it changed to whatever name you like.
Okay, and also I don't want anything to do with the spousal support. I'm dropping all that.
Okay. So that's all we'll be talking about probably then is the motorcycle.
Okay.
Pardon?
Oh, I was just gonna ask you real quickly, is that when I would bring up like the, income taxes that were just taken from me that we need to, I believe I sent you copies of that as well as the Comcast bill and also the Granger bill.
Okay, now you're telling me there's more things than just the
But that's what,
motorcycle,
yeah,
but
I was going to
but
address that,
yes.
you know. Okay.
That's what I will do at a trial. I
Okay.
will hear from both of you. Income tax refunds, debts, who's going to pay what debts, whatever property issues exist. I will hear all of that on the day of trial, and I will make a decision as to who gets what. Okay?
Thank you, sir.
All right. We'll see you both back here on the new trial date and time that you've been provided. Mr. Ramey, you are able to participate by phone if you can't figure out how to make the Zoom thing. Obviously, you can't see what's going on, but my guess is there's probably a setting. Were you using your phone to try to connect?
Yes, sir, I was.
There's probably a setting somewhere on your phone where you can turn on the audio. So just look for audio settings.
Okay.
If it doesn't work, I can call you. We can do it just like we're doing today. Okay?
Okay, I was just worried I was going to miss you. So I'm just grateful that it worked out so that I got to talk to you. So.
Nope, we'll make sure you
Could
get
I
to
ask one quick
participate.
question?
Thank you, sir.
Your Honor,
Yes,
could I
go
ask
ahead,
one quick
miss.
question? Okay,
Go ahead.
the judgment of divorce and the judgment of divorce, the personal property addendum. We have to sign the judgment for divorce, him and I both, correct? And then I can email it to you. So then on the day of the trial, you have it and everything can be done that day, correct?
If the two of you are in agreement as to what should be in the judgment of divorce, yes, you can do it that way. If you're
Okay, so we
not
don't-
in agreement, if you are not in agreement, I will prepare the judgment of divorce.
Okay, that's fine. I just wanted to make sure I was trying to cross all my T's and dot all my I's, you know.
Okay, and do either of you have any more questions?
Oh, yes, I have one question, sir, if that's okay. See, this whole time that me and her have been split up, out of 3 years, we've only been together a year and a half. But the problem I'm having is this whole entire time, we've been split up for quite some time. So any females that I was talking to, say on Facebook or anyone, she has hunted them down and contacted them and came to my house, stole things off to my front lawn, and then texts me and asks me or calls me and say, hey, you notice anything's missing? And she's completely harassed me to the point like I almost can't even deal with it anymore. Is there anything you can put in order that'll have her just completely leave me alone and stop haunting the people I'm talking to? And because it's horrible. She's put me through hell, and I just need that to stop. If there's anything you can do, I'd really appreciate it.
Well, just remind me of that on the day of trial, and we'll see what I
But
can
she'll
do.
haunt me until the day of the trial. What do I do about that? Is there anything you can put in order to stop her from contacting me or haunting me?
I can't do anything between now and the trial.
Okay, understood.
It's just weird that he's doing this, saying that about me, Your Honor, when he's threatened my life, he's threatened my family's life. I mean, it's constant, you know, on
All right.
his girls that
folks,
he's referring to reached out to
Save
me.
it. Save it till the trial date. I will address whatever it is you ask me to. If there's something I can do, I will do it. If there's not, I will tell you that. Okay?
Oh, that's fine. I
Okay,
appreciate
but
that.
if she continues, can I come down there and put some kind of PPO against her or some
No,
order to
I
get her
did that
to stop
live.
contacting me?
You can, either one of you can ask for a PPO. It likely won't be granted ex parte. That means without a hearing. But whenever you file a PPO, it's presented to the judge. The judge decides whether it should be entered immediately or whether there should first be a hearing. So if it's not granted immediately, just make sure you ask for a hearing, and then it'll come back in front of me and I will be able to address it. And if I believe a PPO is necessary, I will grant one.
Your Honor, he did that before and he lied and falsified documents in Charlotte to get one of those against me. which he's
Okay.
admitted and he dropped it. So it's a joke to him.
Okay.
And he dropped it. So it's a joke to him.
All right.
Yep.
Save it for later, folks. This is just a
Okay, no
pre-trial
problem.
today. I'll see you
No
back
problem.
here on the trial date. Have a good day,
Okay.
Mr. Ramey.
Okay.
Ms. Ramey.
Thank you, sir.
You're welcome.
Bye-bye.
You too. Thank you. Bye-bye. Where's that?
Yeah, I'm looking forward to that one. Okay, let's see. I think, let's see, we got Carroll versus Jackson. Let me try that. Well, we got George here. Let's bring him in.
Good morning, Your Honor.
Mr. Lyons, how are you doing?
I'm doing fine. Judge, I want to say one thing. Please let me know when that last couple goes to trial. I want to watch that one.
I think it's May 20th, they said was the trial date. It wasn't, the notice hasn't made it to the file yet, but that sounds like it'll be an interesting one indeed.
Oh, yes, I'll be there I'll be right here with popcorn.
Are you expecting Mr. Christopher to participate this
Your Honor,
morning?
he's at work, so he may not be able to make it.
I've got somebody in the waiting room on a Galaxy device. Let me just see who that is first.
Thank you. Hopefully it is him.
I just let somebody into the courtroom on a Galaxy device. If you can hear me, can you tell me what your name is? Well, I don't have an image. I'm not getting any kind of notice that there's no connection, but my guess is they don't have a good connection. They apparently can't hear me. Looks like the only command I can send is asking them to start their video. All right, something's happening here, I think. No? False alarm.
All right.
I don't know who that is. And unfortunately, there's no way for me to communicate. I'm going to try removing and see if they log back in. Clearly, there's no connection there. Maybe that'll at least get their attention to try another method to contact me.
Not a problem.
So this is the matter of Moog versus Christopher.
Yes, Your Honor.
It's titled A Motion to Affirm Paternity and for Custody and Parenting Time.
Right.
Mr. Miles apparently has already signed an affidavit of parentage with the mother for these two children. Is that correct?
Both children, Your Honor, and I know this court reads his pleading, so I'll be very brief. This is a scenario: a younger guy gets with an older woman. She gets pregnant. She intimates it's not his baby. Then it is. Then it isn't. He tries to preserve the relationship over the objection of his mother and his family, and he signs it. The second time, Your Honor, the second child, he has literally not seen since the day of birth when he signed the certificate. And the same thing. It might not be your baby. Maybe it is. Maybe it's not. Friends are telling him, "Hey man, she's telling people that you're kind of an idiot. And she's got your name on two kids that aren't his." He simply wants to know, Your Honor. He's older, prayerfully wiser. He's been through the ringer. He's had some mental health problems. He's had some drug problems. He's gotten through. He's gainfully employed. His life is on an even keel. he'd like to know for sure that they're his, and if they are his, because he is paying child support, he'd like to develop a relationship because he has no bond with these children, particularly the younger child, Liberty, whom he has never seen since the initial day of birth when he signed the affirmation of paternity. So, Judge, it is a very fact-driven scenario here that we're alleging misrepresentation pursuant to, I believe it's MCL 722.1437, subparents 1 and 7. And we have attached the affidavit pursuant to statute, making similar allegations, which we think supports our position. If they were married, it would have been a much different scenario, as the court knows. But they were not. We don't think it's a stretch to ask to affirmate the paternity and prayerfully move forward with parenting time.
So I was confused as to whether or not you were asking to revoke paternity. I know the motion says to affirm.
Yeah,
but the fact of the matter is, it's too late to revoke paternity. The only thing I can do, and ordering a paternity test is pointless if it's impossible to revoke the paternity because it's too late.
Well, Your Honor, I'm sorry.
So, I mean, I certainly can address the issues of custody and parenting time. That's appropriate, but I don't think I can do anything to change the fact that there's an affidavit of paternity. I mean, even if it was obtained by fraud, you still have to move to set it aside within 3 years of birth.
Well, it has to be
way past that.
Within 3 years of knowledge of the misrepresentation of we're asserting
I don't think so. I'm willing to be educated on that issue, but I don't think so. I think it's pretty strict.
Well, I've done a similar case, if I may, Judge. I'm sorry. I don't want to be like that last couple and keep cutting you off. I do not want to do that. Because I think
some of the cutting off that takes place with Zoom is just the nature of the technology. Sometimes we because there's a little bit of a delay, we end up not realizing the other person has finished talking. So I'm not offended, George.
And I appreciate that, Your Honor. Let me move to find this because I know what you're saying. It is really kind of a weird scenario with these types of cases. But I've done a few of these, and at some point, the court's discretion becomes a moving factor.
Well, let's pull it up. If you've got the citation for the Revocation of Paternity Act, I've got my Westlaw open and I can pull it up. Maybe I can find it before you do.
I got it right in front of me. Let me.
Okay.
We move down. If the court in action finds duress, which is one of the things that we're asserting. I may have to do some further research. I would ask for the order for the DNA, and I'd ask that this be put over to allow me to brief this, because I think the court is right that the language here uses that word that lawyers despise, which is shall.
That was my recollection the last time I look at this, that there was a narrow window when it was first enacted where you could take steps within a year after the statute, but that's long past.
Well, with regard to London, the acknowledgement date does not count if it's filed on no, I'm sorry, I misread that.
I'm certainly willing to give you more time to research and brief, but I'm not going to order a paternity test unless there is a possibility for paternity to be revoked. It's pointless. Even if that test came back and said he's not biologically the father, I still wouldn't be able to change paternity.
Right. Your hands would be tied on that one.
So what I can do, if this works for you, is simply say allow you to not make a decision today, allow you to renotice your motion at a future date, and you can provide me with whatever authority you can find that allows me to do something about the paternity. With respect to the custody and parenting time, that's something I can certainly address.
Okay.
But we need to resolve whether or not we can do anything about the paternity before I start weighing into custody and parenting time. So do you want to just withdraw your motion today and renotice it at some future date?
I will, Your Honor, and I appreciate that. And I'm going to, knowing me, I'll be in front of this computer the rest of the day, because I know there's something. I know that at some point the circuit courts, I knew she was there. I could feel her.
I just want to say hi.
Hello, gorgeous. How are you? Okay.
I'm so good. I'm good. How are you?
I'm great now. That's my courthouse wife, Judge. Okay, Judge, I'm going to get on this, and I'll just renotice it when I have something, because something tells me that there's got to be a safety valve for your discretion where the issues are misrepresentation or fraud. I hope I'm right. I think that you might be right, though. But we shall see.
Okay.
Right.
Fair enough.
Have a good one.
Good to see you, George, as always. Have a good day.
It's a pleasure.
Hello, Peter.
Mr. Lyons, one of my faves.
Ms. Carroll, can you hear me?
Yes, I hear you.
Okay, hold on. Let me grab your file. Oh. I didn't realize that was the same guy. Oh, it's not. Never mind. Never mind. Oh, all right. So, Mr. Jackson filed a motion to set aside the PPO that this court entered ex parte back in March. He is not here, so I'm going to dismiss his motion and we'll keep the PPO in place. Do you have any questions for me, ma'am?
No, thank you. As far as this case, no. Thank you so much, Judge.
You're welcome. Have a good day, ma'am.